of Rupert Law Group. We handle exclusively E-2 and E-1 visas, so no matter what treaty country you're from or in what state you want to be, we can help. Today, we have a very special guest, Anna Kerner Andersson, who is an attorney and a former consular officer who has served at consulates around the world doing E-2s and other visa interviews as well. Welcome, Anna. Thanks for being here.
Thank you so much. Thanks for having me.
Yeah, great to have you. So today we're going to talk about a few things regarding the interview from the consular officer's perspective. So I can give you a lot of information about what I know from an attorney's perspective. And of course, you're the client. You have a lot of information on that end. But Anna is going to give us the perspective of what is the consular officer thinking and what's happening and those types of things regarding the interview. So with that, Anna, let's talk a little bit about the different types of denials. So there's an inadmissibilities, that's kind of its own kind of set, which we won't go over today. That's kind of a different topic, but mostly it's a 221G or a 214B. What are the differences in those, and why would a consular officer give one instead of the other?
Sure. So 221G is what we call a soft refusal. So that's basically the officer needs additional information in order to make their final decision. So that could be a little bit more information about the E-2 entity. It could be as simple as a bank statement, or something that the officer feels like they can't make a final decision without getting additional information. The other reason that someone might issue a 221G would be for a security concern. So as part of the process, when you're an applicant, the officer is going to do a variety of different security clearances, and if something is revealed during that process, it might not be you, but there's processes that the officer has to go through if there's suspicion that there could be a potential match to someone of a security concern. So then the officer has to send that to Washington, D.C. to be cleared out. So that's the most common 221G. Either the officer themselves feel that they need more information before they can issue the case, or there's more security information that needs to be analyzed before the visa can be issued. And then a 214B is what we refer to as a hard refusal. So that's where the officer makes a determination that you do not meet the qualifications for the E-2 visa. So the piece of paper that they'll hand you will say immigrant intent, right? Because that's the letter of the law of what 214B is. But 214B is a very wide and gives the officer a great deal of discretion to deny the visa. So that can be, it doesn't mean that they don't believe that necessarily you're going to return back to your home country. It could be that they don't feel that the enterprise is real and operating. When I was an officer, that was the most common reason that we saw cases denied, was that that people were trying to have it both ways, right? That they were trying to get the visa and then they were going to make the investment. So officers really wanted to focus on, is the business actually operating, right? And so that was a common reason for denial. And then substantial investment is usually typically the other common reason that the applicant hasn't invested sufficient funds in order to qualify for the E-2 visa.
That's interesting. So you're saying that the two most common that you experienced on the E-2 for the 214B, but the two most common reasons for that were the real and operating requirement or the substantial investment requirement, right?
Yes, that's correct.
Interesting. So just as a side note here on the substantial investment. Now, obviously, we know that there's no hard number written into any regulation, law, or otherwise. However, there's kind of a feeling or a vibe. Was there any sort of instruction given to consular officers regarding like a number, or if it's this type of business, it needs to be at least this much, or was it really just a personal feeling?
It really was up to the officer's discretion. So a lot of that comes from, quite honestly, I would read the attorney cover letter and, the argument that was made there, because it's substantial based on the industry or the type of investment, right? So, if you're looking at an IT company that doesn't need the bricks and mortar type of investment, then obviously the investment dollar, it makes sense that that's going to be lower, right? Because you don't need the infrastructure investment. So, I mean, there was no hard and fast rule given to consular officers at all. It really was like, I always say this, but the officers are taught, like, does the story make sense, right? Do all the pieces of the puzzle fit together? And that applies to this too, right? Like, is the investment substantial based on the type of business that it is? Like, does that make sense that, you know, it could be operational and that, you know, that's enough to have a successful business?
Interesting. I love that you say that because I say that a lot too. Like, because people will want very specific information, which I get. Like, well, exactly how much do I need to invest? Well, exactly how many clients should I have? Well, exactly how many employees should I have? And I always say exactly what you just said, which is it's all got to make sense. What would a regular person think? You know, does this all make sense? Like, if you have a restaurant that's running, it's a 24-hour day restaurant and you have 2 employees, does that make sense? Not really. But if you had an accounting firm in Lincoln, Nebraska, could you have 2 employees? Yeah, you could, right? You could still service lots of clients doing. So it all has to make sense. That's really interesting that you say that, because that's exactly what I always tell people. So let's just say, so one thing that you mentioned, going back to the 214B, is that they're going to hand you a paper. And a lot of times they do, but a lot of times they don't. So if someone goes to an interview, they're asked 2 or 3 questions, and then they're kind of like, you know, it's going to be a no from me today. Thanks so much. Have a great weekend. And the person says, well, what went wrong? There's never an answer, right? And they didn't get a paper. What should someone do with that information? Okay, I was just denied. I have no idea why. I was not given any reason. Where do you kind of start unpacking that as the client?
Yeah, that's difficult. And not that I'm trying to sell my services, but typically sometimes we can read between the lines. You know, having been a former consular officer, we can kind of go over with you. Typically, I tell clients, like, if that happens, try to write down the questions that you were asked, try to write
Right.
down sort of the facial expressions that the officer had when you gave your responses. And then if you can share that with us, we can kind of try to figure out, you know, what the officer was thinking. At the end of the day, your options are limited, right? Like, reapplication is kind of your, you know, one of your main options, right? But it, yes, typically a 214B refusal, you know, even if the reason, I mean, the reason matters, of course, but not exactly, if that makes sense, right? Like, you know, you have to just make a stronger reapplication, and then we're, you know, then of course we discuss timing of the reapplication and all of those things as well. But yes, I mean, typically 214B refusals are very cryptic, and they're cryptic on purpose, right? So it's a little bit difficult to know exactly what the officer was thinking, but we can kind of figure it out from, you know, from the questions that they asked and the length of the interview. Typically the interviews are short, but if, you know, the officer delved into specific questions and really honed in on one specific area, then that gives us an idea of what the officer was thinking and what the officer thought was a problem, and why it led to a 214B refusal.
Yeah. Interesting. I think that's one thing we always say too. Like, when did things change? Like, you got up there, everything was cool. Then you said this sentence, and then it kind of was like, oh, I need to go talk to somebody or something like that, right? And that's kind of where you can start doing the math. And also by looking at the application, right? Especially if you did not prepare. I mean, as the attorney, you did not prepare the initial. Looking at that application, sometimes you can tell right off the bat, oh, I see. Well, you didn't include any source funds, or you didn't include any blah, 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 fill in the blank, right? Or it's very like, I see, I'm reading this right here and I don't understand this and that. Could be something like that. So maybe digging more into the documents as well.
Absolutely. Yeah. Identifying areas that might have been weak, both in the verbal interview as well as the written documents.
So here's a question for you. So let's say that someone is denied on a 214B. What would be okay, so and let's say they got the paper. So we know, hey, this is a real and operating situation. That's what's going on here. We kind of know what it is that we're doing. Everybody wants to submit one more contract and then apply like later this weekend. What is your what did you say? And now this is something you have told me off camera before that I found very interesting, that sometimes consular officers have kind of unwritten rules about if somebody reapplies after a week or two, we're just going to go with the initial, like not enough has changed. Tell me a little bit about your recommended timeline for someone? If I'm, it's March 1st and I'm denied for a 214B, we know it's a real and operating, but they get the paper with the circles and all of that. What's the next step?
Yeah, I mean, it tends not to be popular with clients because they want to reapply as soon as possible. But the
Yes.
longer you wait, the stronger your case is going to be, I always say, right? And so, in most of the places where I served, it really was a year, and a lot of my clients don't like to hear that. So, and at a minimum, I would say 6 months. And I think most of my colleagues that are now on the other side and are no longer, consular officers, but are former consular officers, they agree with me. Like 6 months, really, anytime before that, you're going to have significant new evidence that's, substantially different from your first application, because the first question the officer is going to ask is what's changed since the last time that you applied, right? And for them, what's happening internally is that they have to basically go to their supervisor to justify why they're making a completely different decision than their colleague made. And so in some posts, depending on the supervisor, that's an extremely difficult situation, and that can reflect negatively on the officer themselves. So they're not going to take that risk of their own personal career to advocate for you as the applicant, right? So the fact that they're going to do that is pretty limited after 6 months, and that's to maintain consistency in the process, right? Like that's done so that you don't have wildly different answers from different consular officers, right? So there is there's a there's a reason behind the rule, right? But yes, I mean, after 6 months, if you have additional employees, you have additional investment, you've got more contracts, like obviously after 6 months, you can say enough time has passed, I've continued to grow the business, and now I'm in a completely different place. So my kind of general rule of thumb is 6 months. And if you can, obviously it's not a hard and fast rule, you can apply before then, but then you're going to need to be prepared to have significant evidence if you apply sooner than that.
Yeah. So even in that case, right? So we know it's a real and operating. We have the paper. We know it's real and operating. We have, hey, this big contract's coming through in a couple of weeks, so we know we're going to have revenues and all of that. Even in that scenario, you would still advise waiting several months, maybe even a minimum of 6 before reapplying, just because there's kind of this unwritten, like, we got to wait some time. Time needs to pass, right?
Yeah, I mean, it would be very rare, if you come back in 2 weeks' time or a week's time, and now with wait times, that doesn't happen as often. But
Right.
it used to, there were times when I was in London, for example, where we would see that someone would get denied and they'd come back the next day, and and that's an unsuccessful strategy. You're not gonna.
Yes.
I mean, I've never seen a case like that get approved, right? The officer, unless, I mean, there are very, very, extreme circumstances where there might be an officer that has a reputation for denying every single case in front of them, right? And then if the next officer sees that particular person handled the case, then you might have a chance, but that's really rare, right? I mean,
and you would have no way of knowing that, right? As the applicant, you would have no way of knowing that that's kind of what is going on, right? Another strategy that some people want to take, and let me know what your thoughts are on this, but let's say that I apply in Toronto today and I'm denied, this time for substantial investment, and it's pretty clear what it is. I'm a dual citizen, though. That's the good news. I'm a citizen of France and Canada. So why don't I just go to Paris? We'll just apply there. And then, like in 6 weeks, I'll go to my interview in Paris. What do you think about that?
Yeah, so my general rule of thumb is that you should always reapply where the denial was. And it sounds kind of counterintuitive, but the reason why that's important is that the officer, the system is worldwide. So, the documents and not the documents so much, but the notes from the prior interview are going to be visible to whatever consular officer you go to, no matter where you go to in the world. And if you, were recently denied in Canada and you show up to me in France, the first thing I'm going to do is pull up those notes from Canada and see why that officer denied your case, right? And the disadvantage is that, that officer doesn't sit next to me in the window at France, so I can't go over to that individual officer and say, hey, do you remember this case? Do you remember why they denied them? So I'm going to take, the notes, which are typically, if they're going to deny a case, are pretty negative, right? Because again, they're justifying to their supervisor why they made that decision. So they're going to be fairly negative. So I take those notes at face value. And it's going to be awful hard for me to justify why I'm overruling a colleague that I can't speak to, and I'm going by just the notes, right? And so then I'm going to think, well, why are you here, right? You're here because you didn't get the answer you wanted, and now you're trying to find a place that has a higher approval rate, right? So we call internally we call that visa shopping. And the minute we see that, we get suspicious that the case isn't very strong and it's probably not a good issuance. So that's where you want to be very careful. Like some people are hesitant, because it logically doesn't make sense. You just got denied. Why would you go back to the same place? But it does actually internally make more sense to go back to where you are. Now, if you're a dual citizen, right, like that applies more if you have no connection to the place that you do the second application at. That to me is very risky. But if you're a dual citizen and you could explain, well, my kids are in school here, or it's summer vacation, so we spend an extended period of time here. If you can explain why you're now in France after a denial in Canada, and you're a dual national, then it's going to be less suspicious about visa shopping, right? But again, it goes back to the story needs to make sense, right? There has to be a reason why you're reapplying in a different place.
And if you're given the opportunity to even state that reason, right?
Right.
You may not even be given the opportunity to even answer that question, maybe, depending on where.
Most likely you won't be directly asked it, but I always tell people it's a very prepared applicant wants to try to anticipate the questions the officer has as much as possible. And I mean, that's difficult, right? But that if you know that you're reapplying shortly after a recent denial in a different location, that's the first question the officer is going to have on their mind. So you as the applicant, I always say that's kind of your job to proactively answer that. Yes, the officer is probably not going to say, hey, why are you here? But when they say, why do you want to go to the US, or tell me a little bit about the business, you can intertwine, that answer into your question so that it, makes sense. It doesn't sound like you're answering a question way off base that the officer didn't ask, but you're already answering a question that proactively that the officer has in their mind.
Yeah, that's interesting. If you have any questions about the E-2 visa process or the interview, please reach out anytime. We'd love to speak with you about your E-2 visa.